and found the deceased in a very emotional state, and she told her mother that she wanted to kill herself by hanging.
I got called a racist when I'm not a racist.
You might as well have called me the N-word.
I'm not even supposed to be in jail.
On Christmas Eve 2018, a confrontation over a parking space in a McMinnville, Oregon, strip mall escalated into a widely publicized incident involving 39-year-old Amber Rocco. According to video evidence and witness accounts, Rocco approached Amora Robertson, her boyfriend Keeson Goodyear, and a family member while they were parked. During the dispute, Rocco was recorded shouting racial slurs, waving a weapon, slapping Goodyear, and slamming a car door on Robertson, which caused an injury. The video went viral online, sparking outrage and leading to Rocco's arrest on multiple charges, including intimidation, unlawful use of a weapon, menacing, harassment, and assault.
I do 100% from the bottom of my heart regret saying that word. I've never in my life used that word. I have a very mixed family and I love them. I love everybody equally. I would never use that word ever again. I'm hoping for the best because it really got blown out of proportion. I got called a racist when I'm not a racist.
In court, Rocco issued a brief apology, though in later interviews she claimed she was the victim, stating she had been slapped and was simply defending herself.
As I defended myself as a human being, it got blown way out of proportion. And if people actually pay attention to the video, the last 50 seconds of that whole entire incident, everybody will realize I was defending myself.
Despite her attempt to reframe the narrative, the court and public response reflected the severity of her actions. In April 2019, Rocco entered a plea deal, admitting guilt to second-degree intimidation, unlawful use of a weapon, and 2 counts of harassment. She was sentenced to 30 days in jail, 3 years of formal probation, and 80 hours of community service. In early January 2023, Detroit-based attorney Lillian Diallo, who was undergoing treatment for breast cancer, requested to attend a sentencing hearing virtually in Ottawa County Circuit Court, Michigan.
I don't take any great comfort in having to say this out loud, but the truth is what the truth is. You might as well have called me the N-word. What she was doing up there.
She made the request after seeing the virtual appearance option listed on the court's website and explaining her medical condition to the clerk. However, her request was denied, and she was told the court did not permit virtual appearances.
I asked her clerk. I said, well, can I zoom in? No, we don't do that out here. I'm like, oh, but I was reading. I'm like, okay, fine. So I went in there because you ultimately don't want to put your client in a worse position.
Prioritizing her client, Diallo drove 3 hours to attend in person, only to discover that another attorney, who was white and also dealing with a medical issue, was allowed to appear remotely for a similar proceeding.
The lawyer was on the screen, allowed to zoom in for the same kind of proceeding, a sentencing, right? He's white. And I'm not.
During the hearing, Diallo's client, a young first-time offender with no prior criminal record, was denied a deferred sentence despite meeting the eligibility criteria and receiving a favorable recommendation from probation officers.
She does not give him a deferred sentence, even though he's eligible, and her own probation department recommended it, right? First time, not even a parking ticket. And I'm not making any excuses, but I'm saying you have to give us parity.
Diallo raised concerns about the unequal treatment and filed a grievance against Judge Karen Miedema with the Michigan Judicial Tenure Commission. She cited violations of the Americans with Disabilities Act and a lack of judicial fairness, claiming the situation reflected implicit racial bias. The court denied any discriminatory motive, stating they were not fully informed of the extent of her health condition. Nonetheless, Diallo's experience gained media attention, raising broader concerns about equity and transparency in courtroom procedures. In Hillsborough County, Florida, 75-year-old Cynthia Latson was arrested and jailed for contempt of court after missing hearings related to the care of animals at her home. The situation began when neighbors raised concerns about the number of cats and dogs she kept, leading County Animal Services to allow her to retain the pets under specific conditions. However, authorities later claimed she failed to meet these requirements. After missing 2 court dates, a judge issued a contempt order, resulting in her arrest.
No one had reached reached out to me or my sister to ask us, or to ask us for help and find out, well, why did she miss these 2 court dates? Sometimes they're forgetful. They can't always make their court dates. This had to do with a missed court date. And they need to show a little compassion.
Her family expressed frustration, stating they were not contacted before her detention, and emphasizing that her actions stemmed from a deep affection for animals rather than malicious intent. The arrest sparked public outrage, with many criticizing the treatment of an elderly woman over missed court appearances related to pet care.
It's been 2 days. It's been 2 full days just about at this point. So we're all happy that she's out and getting ready to go home with her and help her settle in. So we'll be working with animal control to make sure all the requirements are met.
On May 12, 2017, just before Mother's Day, a judge ordered her release, acknowledging the family's concerns and the disproportionate nature of the punishment. Her family hopes this incident prompts a review of county policies to prevent similar situations involving elderly individuals in the future. Oakland County Circuit Judge Lisa Gorcyca faced national scrutiny after she threatened 2 boys and a girl with juvenile detention for refusing to spend time with their estranged father during a high-conflict custody case.
You want to have your birthdays in Children's Village? Do you like going to the bathroom in front of people? Is your bed soft and comfortable at home?
Frustrated by the years-long parental dispute, Gorcyca told the siblings that they would be sent to a juvenile facility for defying her court order. Her handling of the situation drew widespread criticism, leading to an investigation by the Judicial Tenure Commission, JTC, which accused her of abuse of power and judicial misconduct. A special master appointed to the case found that Gorcyca had abused her contempt powers, made inappropriate gestures and comments, and provided misleading explanations during the investigation. While the JTC recommended a 30-day suspension without pay and public censure, the Michigan Supreme Court ultimately issued only a public censure, deeming it a proportionate response to the misconduct established. In December 2012, LaRue Ford, a 49-year-old social worker from Indiana, traveled to Berrien County, Michigan to settle an old traffic ticket. After facing delays and what she described as frustrating interactions at the courthouse, she profanity under her breath while exiting the clerk's office. That brief moment of frustration led to an unexpected turn. Ford was arrested, charged with contempt of court, and jailed for 11 days, including over the Christmas holiday. Unable to afford the $5,000 bond, she remained in custody as her case drew national attention. Civil liberties advocates, including the ACLU, condemned the arrest as a violation of her First Amendment rights and an extreme response to a moment of vented emotion. On January 11, 2013, Circuit Court Judge Charles Lasada dismissed the contempt charge, citing improper handling of the matter by court staff.
I guess right now I'm just speechless. I'm tired, and I've just been through so much.
It was later revealed that Judge Dennis Wiley had initiated the contempt charge based solely on secondhand reports from clerks without a sworn statement or formal hearing. The Michigan Supreme Court issued a public censure against Wiley, citing violations of judicial conduct.
What do you think of them charging you like that?
Well, I'd rather not say. It may land me back in jail. People get a little angry, and they vent out different ways, but I would have never thought it would have landed me in jail.
Do you think you'll think twice before you get heated up again?
Well, I know definitely not to just wait until I get inside of my car.
Though Ford was relieved the case was dropped, the ordeal left her emotionally drained. She later shared that she learned to better manage frustration in official settings, but questioned how a single word had derailed her life for nearly 2 weeks. In 2015, Las Vegas judge Melanie Tobiasson became concerned that her daughter was being targeted by a trafficking operation tied to a Chinatown clothing store. Suspecting Shane Valentine, a known felon, she alerted police but felt they failed to act.
I spent hours. I mean, I would go, I would watch, I would get license plate numbers, I would get makes and models of cars, I would follow people, I would get information about where they would go, where they lived, where they, I never used inappropriate means to get information, I did it all myself.
Taking matters into her own hands, she began conducting personal surveillance and sharing findings with the mother of Sydney Land, a young woman later murdered alongside her boyfriend in 2016. Tobiasson's unofficial investigation included the use of burner phones and covert communication, which eventually raised serious ethical concerns.
The problem is I don't think we're in danger from the pimps anymore. I'm more afraid of the vice detectives and those who are trying to cover this up. That's what I'm afraid of.
Her actions led to an inquiry by the Nevada Commission on Judicial Discipline, which accused her of misusing her judicial position and failing to remain impartial.
I would lose my job over this. I would lose my freedom over this. I would lose my life over this.
Facing 8 misconduct charges, Tobiasson resigned in 2021 and agreed not to return to the bench. On January 20th, 2023, she died by suicide, less than a year after Connie Land, her collaborator, and Sydney's mother did the same. The double homicide case remains unsolved, with no charges filed against Valentine. In February 2017, 31-year-old Gavanni Ramon Jones, a homeless man in Muskegon, Michigan, asked to stay the night at the home of a woman he had known for about 6 months. She agreed, but later that evening, Jones turned violent. After the woman received a phone call, Jones allegedly dragged her into a bedroom, where he forced her to perform non-consensual activity. She testified that she repeatedly resisted and made it clear she did not consent. Jones was later arrested and charged with first-degree criminal conduct. In 2019, he was convicted and sentenced to 62 to 90 years in prison. While awaiting trial, Jones was charged with indecent exposures after exposing himself to jail staff. During a preliminary court hearing on September 5, 2017, he disrupted proceedings and was held in contempt of court.
Excuse me, I want to have a minute.
Stop.
I need to
Sir, you cannot interrupt the court proceedings unless you want to be held in contempt. And as I already indicated, I'll give you an additional 90 days. She will be attentive to you in terms of answering any questions you have, but you don't get to interrupt. I have no witnesses, yeah. Thank you.
Excuse me.
Do not interrupt.
Yeah, but I have a constitutional right to say that I want to testify about what was said, and so.
Sir, I'm going to let you talk to your attorney for a brief moment.
Okay, but first of all,
Sir,
before I talk to her about something.
All right, that's it. I'm holding you in contempt.
How you gonna hold me in contempt and I have a
I'm holding
constitutional
you
right to represent myself? Like I said, you know, I was trying to explain to her details about what she was saying about bathrooms and stuff like that. I was trying to correct something about that and testify about what actually was going on. And so, but you know, I had a conversation with her where I was trying to let her know a lot of different things that's been going on in jail. And I sat here and I was listening to her representing me, but I never signed any paper for attorney representation. So, you know, I don't know exactly what was going on, you know, but I do would like to testify because I got a First Amendment, Sixth Amendment, Eighth Amendment, and 14th Amendment right to represent myself, Judge. And also, I want to say that I have been in front of 5 district court judges now.
Stop right
now. Neither one
Mr.
has
Jones, listen to the judge.
Serious medical needs as important.
Sir,
Nor
I'm going to
has
hold you in
anyone
contempt.
of these judges appropriately
You want him out, Judge?
Yes, sir, you have the right at this time.
I'm not struggling, so why you dragging me? I mean, this is what y'all do all the time. Y'all harasses me. I've been harassed a lot in jail over and over again. I'm not even supposed to be in jail.
That same year, he assaulted both a police officer and a prison staff member, resulting in additional charges and convictions. These offenses extended his prison sentence. He is currently serving his time at Gus Harrison Correctional Facility, with the earliest possibility of release in March 2079. In September 2023, a tragic accident in Hartford, Connecticut, took the life of Detective Bobby Garton and left his partner, Detective Brian Kearney, seriously injured. The incident occurred when 18-year-old Richard Barrington fled from a routine police stop. In his attempt to escape, Barrington ran multiple red lights and crashed into the police cruiser that was responding to a separate call. The collision proved fatal for Detective Garton and sent shockwaves through the Hartford Police Department and the broader community. Barrington was arrested shortly after the crash and charged with first-degree manslaughter, first-degree assault, and interfering with police. From the beginning, the case stirred intense emotion, not only because of the loss of a respected officer, but also due to the youth and clean record of the defendant. Rather than go to trial, Barrington decided to plead guilty. His legal team presented a portrait of a young man who made a terrible mistake, emphasizing that he had no prior criminal history and accepted responsibility early on. While in custody, Barrington earned his high school diploma and expressed his desire to continue his education. He also showed visible remorse during court proceedings, even crying, while family members of Detective Garton delivered their impact statements. On June 19, 2025, Barrington appeared before Judge David Gold for sentencing. The courtroom was filled with emotion as Garton's loved ones shared the deep pain they've carried since the crash.
Did Bobby look to the right to signal Brian Clare? Did he see the defendant's car approaching? Were the defendant's headlights the last thing Bobby saw on earth? Was he afraid? Those thoughts haunt me.
His brother, Will Garton, spoke about all the moments they would now miss, weddings, vacations, and watching their families grow together.
Because of this, I won't get to stand beside Bobby at his wedding the way he did at mine. I won't get to celebrate with him when he has his first child, as he did when I had mine. Our families will never take vacations together or watch our children grow up side by side in the backyard.
The one thing I have missed is our one-word text we send each other before a shift ends, status, to check in when we're getting out. My last text to Bobby on that night was let him know that I had tickets to the Yard Goats game. We plan on attending with friends on that Friday.
This feels like a crack in my brain that won't close. Yet I still have to show up like I'm fine. I'm not fine. Not even close.
Officer Kearney addressed Barrington directly, saying, "You took my partner from me, but me and you are square," a quiet declaration of closure and forgiveness. Kearney's wife detailed the difficult months following the crash, including hospital visits and the long process of healing. In response, Barrington stood and offered a direct apology to the families and the police department, acknowledging the harm he caused and expressing sorrow for their suffering.
I always thought I'd be on to a better chapter in my life today. I know I can't bring back Officer Bobby Garton or Hill Officer Brian Kearney back to full health, but I want you to know that if there's anything I can do to give you that closure, I'm here for that, so please don't hesitate to reach me.
Judge Gold acknowledged the severity of the offense, but also recognized Barrington's remorse, youth, and decision to accept responsibility.
The defendant's total effective sentence shall be 30 years incarceration.
He sentenced Barrington to 30 years in prison with 14 years suspended, meaning he will serve 16 years behind bars. Upon release, Barrington will face 5 years of probation. During this period, he will be required to participate in substance abuse treatment and make an annual donation of at least $50 to DCDC cadets, a youth program Detective Garton supported. Though the prosecution had requested 20 years, and Garton's family hoped for a longer sentence, Judge Gold explained that the law required him to weigh all factors, including the defendant's background and sincere remorse. In a quiet neighborhood in Pembroke, Kentucky, tragedy struck in November 2015 when 3 residents, Calvin Phillips, his wife Pamela, and their friend Edward Dansereau, were found dead under disturbing circumstances. Calvin was discovered shot in his home, while the bodies of Pamela and Edward were located in a vehicle nearby. The case immediately drew public attention, especially when it was revealed that Calvin was set to testify in a military case against his neighbor, Christian Kit Martin, a former Army major and commercial airline pilot. For years, the investigation lingered without an arrest, until May 2019, when authorities apprehended Martin at Louisville International Airport just as he was preparing to board a flight. Prosecutors alleged that Martin had carefully planned the murders as a preemptive move to silence Calvin Phillips before the upcoming court-martial, where Calvin was expected to testify against him. The case was later moved to Hardin County for trial due to extensive media coverage. In June 2021, after several weeks of testimony, a jury found Martin guilty on 3 counts of murder, 2 counts of first-degree burglary, 1 count of first-degree arson, 1 count of attempted arson, and 3 counts of tampering with physical evidence. Prosecutors described the crime as a calculated operation, methodically executed with military-like precision. They supported their case with ballistic evidence, a GPS trail, and Martin's own dog tags found near the scene.
All right, is there anything you all want to say in mitigation of punishment?
Judge, would it be all right if I remove my mask briefly?
Yes.
Judge, I briefly wanted to address the court on Mr. Martin's behalf. Judge, like yourself, I've dedicated my life to attempting to seek justice through the jury system, and we believe in this case the jury did not get it right. We believe justice was not done. We did approach this court to ask the court to set aside that verdict and order a new trial. Your Honor has ruled against us in that matter. And now we plan to go on to the Kentucky Supreme Court, and it is our hope we will prevail there. That's what I wanted to say, Judge.
All right. Is there any legal reason my sentence should not now be imposed?
No, Judge. No.
All right. Mr. Martin, as you know, this matter was brought on for trial by jury beginning the 2nd day of June 2021 through the 17th day of June 2021 on a change of venue in the Hardin Circuit Court. And you were present throughout those proceedings with your attorneys. And the matter was presented to a jury which returned verdicts of guilty on 3 counts of murder, 2 counts of burglary in the first degree, 1 count of arson in the first degree, 1 count of criminal attempt to commit arson in the first degree, 3 counts of tampering with physical evidence. The jury imposed sentences of life in prison without the possibility of parole on each of the murder charges, 20 years on each of the burglary first-degree charges, life in prison on the arson first-degree charge, 20 years on criminal attempt to arson first-degree, and 5 years on tampering with physical evidence in all 3 of those counts. Under Kentucky law, the fact that your offenses involved the use of a firearm makes the sentences violent offenses, the murders at least violent offenses, and you are not eligible for probation. Therefore, it is the judgment of this court that you be sentenced accordingly as I have described the jury verdicts. and those sentences will run concurrently for a total sentence of life in prison without the possibility of parole. You are continued in the custody of the jailer of Christian County until such time as the Kentucky Department of Corrections determines where you will be incarcerated.
At his sentencing in September 2021, Martin was handed a life sentence without the possibility of parole for each murder conviction. Additional sentences for burglary, arson, and tampering were ordered to run concurrently. The judge, referencing the violent nature of the crimes and the use of a firearm, stated that Martin was ineligible for probation and would spend the rest of his life in prison. Martin's defense team contested the verdict, claiming the jury had reached the wrong conclusion and vowing to appeal the case to the Kentucky Supreme Court. That appeal led to a partial ruling in October 2023. While the High Court upheld the convictions for murder, burglary, and evidence tampering, it reversed the arson-related convictions due to insufficient proof. Now in prison for life, Martin's case stands as one of the most haunting in recent Kentucky history. In October 2023, tragedy struck in Jackson, Michigan, when 30-year-old Sebastian Igafo-Teo was found to death inside his home. The discovery shocked the community. He had suffered wounds in what authorities later described as a brutal and violent attack. Investigators quickly focused on two suspects, Joshua Keith Pirtle, age 32, and Clara Deanne Mishaw, age 29. The two had reportedly arrived at Sebastian's house in a stolen vehicle. What happened inside the house is still unclear, but after spending time there, talking, laughing, and even stepping outside for a conversation, they went back in. By the time they left, Sebastian was dead. Initially, both Pirtle and Mishaw were charged with murder. Prosecutors believed Pirtle carried out the stabbing, while Mishaw was accused of helping him, or at least failing to intervene. A key witness in the case, however, gave inconsistent statements, sometimes describing Mishaw as involved, other times suggesting she was silent and possibly afraid.
This was a heinous, and if the court or anyone in this courtroom thinks for 1 minute that I don't feel for Sebastian's family, that's just simply not true. But the killer in this case is Mr. Pirtle, not Miss Mishaw. The evidence in this case, I think, just from the one witness, who, by the way, gave so many inconsistent statements as it pertains to my client, I think Mr. Cush was pretty much spot on with Mr. Pirtle for the majority of his statements that he made. Regarding Miss Mishaw, he was all over the place. 1 minute she was there, she says turn out the lights. The next minute she appears to be the victim of domestic violence and sits there and says nothing and does nothing. In fact, that part is actually throughout the entire investigation. Mr. Cush makes it clear throughout it. Miss Mishaw doesn't say anything. She doesn't do anything. She doesn't bring the She doesn't give Mr. Pirtle the knife. She doesn't encourage Mr. Pirtle to kill Sebastian.
As the case moved toward trial, it became apparent that the witness testimony would be difficult to rely on. With the murder trial looming and the evidence against Mishaw unclear, she was offered a plea deal. On April 25, 2025, she entered a no-contest plea to 1 count of being an accessory after the fact to a felony. In exchange, the murder charge was dropped. Then, on June 18, 2025, Mishaw appeared in court for sentencing. The victim's family was devastated. During emotional victim impact statements, Sebastian's parents recalled the horrifying scene and the pain of losing their son.
My son was a good boy. Not many fathers can say how much they knew that their son cared and loved them. I'm one of those few. I don't know what went on in that house. I wasn't there. What I do know is that they went to that house, her and their partner, in a stolen vehicle. They played games, laughed and joked a few hours, went outside, had a discussion, went back in the house, killed my son. They left. Couldn't start that car that they came in, right? So somebody had to go back in that house and look for my son's truck keys. You know, I'm not saying that she was involved in the and all that. I don't know that. But I can tell you this. I've seen people do more time for being somewhere than she's getting.
Something was very wrong. Inside, my husband saw Bash on the floor of his kitchen. There was everywhere. I heard Billy make the most horrifying cry. Oh, God. Bash, no! I'll never forget that sound as long as I live in the brokenness of his voice. Bash had been brutally murdered. I was steps behind, so I saw him too. Billy told me to get out and call 911. I remember asking Billy if he was dead. Billy said, "I've seen dead." Billy's a military veteran. "He's gone," he said. "I've seen dead." We later found that he'd been stabbed at least 73 times.
His father remembered the moment he found Sebastian on the floor, surrounded by blood. His mother described the deep emotional scars that remain and voiced frustration that Misha would avoid prison altogether. They didn't claim she committed the stabbing, but believed she played a role and should have faced a harsher penalty.
They brutally lost a son, a father, a brother, a friend, a nephew, a member of our community. But here, when we're in court, we can't just rely on those feelings. And as prosecutors, we have ethical and legal obligations and that we are bound by, and we are bound to follow the law. We are bound to be truthful in the evidence that we disclose, the good, the bad, favorable, unfavorable. We must make decisions that are difficult when witnesses may lose their credibility and change their stories. We're bound by rules of evidence about what prior acts or behaviors we can present in court. And while that's frustrating, that law is something that we have followed throughout this process and that we have followed today as we have painstakingly gone through the calculation of the guidelines, fitting the facts to what's appropriate, and it's based off of following that law that we request the court to consider the brutal nature of this offense. Also, Ms. Misha's failure to abide by her bond conditions when she was previously out on bond, and to sentence her at the top of those guidelines to a term of imprisonment in MDOC.
Prosecutors asked for a tougher sentence, pointing to her prior bond violations and the disturbing details of the case. But ultimately, the court followed the terms of the agreement. Prosecutors explained their decision, stating they were legally and ethically bound by what the evidence could support. Judge Susan Jordan sentenced her to 36 months of probation rather than prison time. In a highly scrutinized South Carolina case, the long-standing legal proceedings surrounding the death of Sarah Lynn Colucci took a pivotal turn in June 2025. Her husband, Michael Colucci, had been accused of causing her death in 2015. Sarah was found lifeless in May 2015 near the couple's jewelry store in Somerville. While the circumstances raised immediate concerns, the initial investigation did not result in charges. It wasn't until a year later, in 2016, that prosecutors brought a murder indictment against Michael Colucci, alleging he had staged the scene. Central to the case was a deeply emotional backdrop. Sarah had previously lost her first husband under tragic circumstances, and those close to her noted that she struggled emotionally around the anniversary of that loss. Just days before her own death, Sarah's mother, Barbara Moore, visited her and found her deeply distressed. Moore later testified that Sarah confided in her, expressing extreme emotional pain and thoughts of ending her life, but also shared her hesitation due to her family. Moore became so concerned that she considered seeking hospitalization for her daughter. After Sarah's passing, Moore says she reported this alarming conversation to the lead investigator. However, the investigator denied ever receiving that information. Compounding the issue, Moore's handwritten statement made no mention of the conversation, and the information never made its way to the grand jury or to Colucci's defense team. During the first trial, which ended in a mistrial, Moore was cut off on the witness stand when she began discussing what her daughter had told her. The prosecution cited hearsay concerns and never asked the court to formally rule on whether the statement could be admitted under an exception for emotional or mental state disclosures. What troubled the court in 2025 was that multiple medical and forensic experts were never given access to this key information when it could have influenced their assessments. Though Sarah's mental health challenges were part of the known record, she was under psychiatric care and had a history of substance misuse. The specific remarks she reportedly made shortly before her death were withheld. During pre pretrial proceedings for the retrial, this omission came to light. Judge Roger Young ruled that the failure to disclose such critical information amounted to a serious breach. He emphasized that had a conviction occurred, it would likely have been overturned for violating the defendant's right to fair evidence disclosure.
Yes, sir.
All right, well, I've considered this matter, and I want to make clear that when I speak of prosecutorial misconduct, I want to make certain that you understand that I'm not speaking of members of the prosecuting attorneys per se, but because of state actors for whom the state is responsible. Under the case of Kyle versus Whitley, this case alleges that the husband of the deceased murdered her, and the defense claims that the deceased committed suicide in part because she was still emotionally distraught by the suicide of a previous husband. And the date of this incident was right around the anniversary date of that suicide. This was a very unusual and dramatic suicide, and it was known to family members that the deceased never got over it and had a very difficult time emotionally around the anniversary of that suicide. The critical issue in this case was that the deceased mother went to the deceased home several days before this incident and found the deceased in a very emotional state, and she told her mother that she wanted to kill herself by hanging. But she did not want to do that to her children, and the mother was so upset that she wanted to have her hospitalized. And after the deceased died in this case, the mother has now testified that she told the lead investigator about that incident within a few days. The lead investigator denies that she told him at that time, and he buttresses his story by pointing out the mother hand wrote out her statement, and she did not mention this prior statement or this prior incident in the written statement. Well, the defendant was indicted at the first trial, ending in a mistrial. The mother did not mention the prior incident at that trial because she was cut off by the prosecutor when she started to talk about what the deceased said. The prosecutor testified that she cut her off because of hearsay concerns. I note there was never any attempt by anyone to allow the mother to testify about the deceased statement under 8033 under our rules of evidence, so the court never ruled on it. But while it was known to all that the deceased suffered from severe drug and alcohol abuse and was being treated by a psychiatrist at the time of her death, evidence was presented at trial of the same. It's very troubling that the evidence that the deceased made specific threats of wanting to kill herself just days before she died. This information was kept from the jury. By state action or inaction, had the defendant been convicted, this court has no doubt it would have been considered a Brady violation, and the defendant would have been granted a new trial. The beginning of a new trial is exactly where we find ourselves today. The state argues with some authority and precedent that basically this court should treat it as the equivalent of no harm, no foul, and that now that this information is known, it can be presented to the jury, who can evaluate it and give it whatever weight it determines it deserves in arriving at a verdict. Indeed, this court believes that it is a choice among several that would no doubt be upheld on appeal if this trial were to go forward and the defendant was convicted. However, this court believes that our courts should demand better from the state, and to simply allow this trial to go forward with so many witnesses, such as pathologists, having been denied the opportunity to have this critical knowledge available to them when that material was fresh, amounts to a foul with a harm. Therefore, this court is quashing this indictment without prejudice and ordering that if the state wants to retry the defendant, It is to do so only after the case has been resubmitted to a grand jury who shall have the benefit of the full measure of evidence this matter deserves. This court recognizes this is an unusual remedy. However, this is an unusual case. And this court urges the Attorney General to present a fuller case to the grand jury than is usually done in state court in South Carolina. The goal is to do justice, and this case deserves a fresh restart in order that the citizens of South Carolina can have full confidence in whatever the jury's verdict may be. It is so ordered. All right?
Thank you, Judge. We are grabbing an exhibit to supplement into the court record of a text message that was shared on May the 12th, which would have been, I believe, the same day that they're alleging this happened, where the victim says, said to Michael, "I'm telling you that I love you. I'm shooting myself in the woods." That is a specific example of her saying that she's going to kill herself, which was one of the reasons why you stated that, Judge. So we just want to supplement that into the record since that was turned over in 2016 to them as well. So we will be adding that as a court's exhibit.
Judge, likewise, we have the videos that were played during the hearing on a thumb drive labeled as court's exhibit number 4 that we believe also needs to be part of the record.
All right. Now, I have quashed this indictment. Therefore, there are no charges pending against Mr. Colucci at this time. So there's no longer a bond on him, and he does not have to have electronic monitoring. If and when he is re-indicted, then bond can be addressed at that time. All right, we're adjourned.
Thank you, Your Honor.
I'm going to go address the jury.
In his ruling, Judge Young quashed the indictment without prejudice, allowing the state to refile charges if they choose, but only after presenting the complete case to a new grand jury. He insisted that justice demanded a full and transparent presentation of evidence to ensure public confidence in the legal outcome. Supporting the defense's position, the court record was supplemented with a text message Sarah had sent on the day she died, expressing despair and explicitly referencing intentions to harm herself. That message, originally shared with investigators in 2016, had not been part of the earlier proceedings. With the charges now dropped, Michael Colucci is no longer under bond or electronic monitoring. In January 2017, a troubling incident unfolded near the Michigan State University campus at an off-campus apartment where 3 MSU football players, Demetric Vance, Donnie Corley, and Josh King, were involved in a sexual misconduct case. A female student reported that she had been taken advantage of during a party at the apartment, leading to criminal charges against all 3. Josh King was also accused of secretly filming the encounter without her consent. The university took swift action, following a Title IX investigation, which found the players in violation of university policy. They were dismissed from the football team and expelled from MSU. Legally, they faced serious charges, including criminal sexual conduct, but eventually entered a plea agreement in April 2018. Under this deal, all 3 pleaded guilty to a felony count of seduction, a lesser charge, and King also admitted to the charge of surreptitious surveillance. During the sentencing, each of the young men took the opportunity to express remorse. Vance shared that the situation had taught him a hard lesson about accountability and decision-making.
Good morning, Your Honor. I would like to say this case taught me a very important lesson in my life, to be very careful with the choices I make and to never play with my blessings in life. I'm very sorry for letting people down that believed in me, that took the time with me to become the person and the student athlete that I am today. I would like to say this taught me a very serious lesson in my life, so now I take my experiences and tell youth athletes like myself I come in contact with to look at me as an example on how fast you can miss out on your opportunities and change in your situations. I look forward to graduating from college and pursuing my life dreams of playing football. Now and in the future, I will always coach and mentor youth so they will make good choices, and I will also make good choices myself to contribute to the community.
Sir, what have you learned from this?
I learned a lot. I learned that this is just to never make bad decisions in your life. Stay stuff can really impact your future and really impact others. And I never want to get into like a situation like this ever in my life.
So what are you going to do to avoid that?
My future goal is to help other kids.
I heard that. But how about you? What are you changing in your life to avoid this again?
Just stay out of all bad situations and just be mindful of my decisions.
Well, at least you, sir, have recognized this was a bad situation and a bad decision.
Corley, while stating he did not consider himself guilty of assault, acknowledged the poor judgment and harm caused, recognizing the situation was inappropriate and hurtful.
That's right. I would like you to know that I do understand the whole situation. I do believe that I didn't do anything wrong as in what the rapist part of it, but I do understand that we all are hurt in this situation. She had to go through a lot of stuff, just like they were saying. I had to go through a lot of stuff, her family and my family and everything like that. I do realize how much mature and responsible I need to be going on with my life. And I have tried to talk to people about putting themselves in bad situations. I feel like I was just in a bad situation. We could have avoided this. And I thank you for letting me talk to you about how I feel.
And you're not requesting to withdraw your plea either?
No, I'm not.
And you understand that what all three of you did was wrong?
Yes, I understand. I don't understand the rapist part of it because we did not rape her, but I do understand that this wasn't respectful to do at the time at a party and timing and everything. It wasn't respectful in that manner. I thought that was very wrong of us, but I don't feel like I did anything wrong as in this part. I don't think I didn't do anything like that.
So she wasn't treated as a woman, she was treated as a plaything. You understand that's wrong?
Yeah, I understand that's wrong, but we actually understand all of what you're saying. I actually understand that part you're asking, but I didn't just do anything wrong as in what people may paint the picture to see that we did.
I think Your Honor, what he's saying is he recognizes that he shouldn't have engaged in the behavior. He recognizes that was wrong, and it's a crime, but he objects to being labeled.
You understand how people could come to that conclusion, 3-on-1?
Yes, I understand that, Your Honor.
You understand that behavior can never be repeated again?
Yes, I understand that.
You understand you need to respect women?
Yes, ma'am. I definitely do.
Your attorney talked about you being immature. Let me just tell you, I expect on this probation, and this goes for all of you, to be mature, to be thoughtful, to follow 100%, because nothing will mature you faster than prison, and no one will send you quicker than me. Do you understand that, sir?
Yes, ma'am.
King admitted his actions were immature and wrong, particularly the video recording, and he expressed deep regret for the consequences others had faced.
Dan, I just want to say thank you for giving me a second chance and a chance to speak here and just to tell my truth and just to tell what I learned and what this situation taught me and what just going through this for the past year and a half and just seeing the changes and effects that it had on my family, the people I love, and it hurts. I didn't want to see them going through that. And most of all, I feel sorry. I feel sorry for all the harm I caused, not just for me and my people, but just for everyone that went through this. This was a problem for the school, for the team, for the victim, for their families. No one should have to feel like that. And I understand that the actions I did back then were stupid and childish and shouldn't be done. I understand that I am very in the wrong for sending out a video of the actions that were taken. Most things like that should be kept private, and I admit wrongdoing in that sense.
That video, you didn't have her consent, did you? Did you have her consent to take the video?
To take the video, I was wrong to send it out.
I understand, but you weren't just wrong to send it out. You were wrong to take it in the first place, right? She didn't willingly participate in that, did she? Okay, so let's start with that understanding. We don't videotape anybody without their permission, and certainly not in that position. Do you understand that, sir?
Yes, Your Honor.
Has all of that tape that you sent out been retrieved?
Yes, Your Honor. There's nothing left.
Your Honor, the
Those
police
streams
could
of
not
video.
recover the videos. There are not copies of that elsewhere. They were Snapchat, so they immediately
Delete.
destroy into the universe, delete. And so, no, we don't believe there are any videos out there remaining in any way, shape, or form.
Is that correct, sir?
Yes, Your Honor.
Sir, your attorney started off by saying what a hard life you had. Well, you've just made somebody else's life hard forever. You don't have the right to say, I had a hard life, so I'm going to do what I damn well please, and somebody else is going to pay for that. You need to make your life better and other people's lives better because yours is better. So it does seem that you have at least the beginning of an understanding, but you have a ways to go. But I am happy at least that you're not standing there saying you didn't do anything wrong, because you did a lot wrong that evening, didn't you?
Yes, Your Honor. I understand.
Judge Aquilina was firm but constructive in her remarks. She emphasized that poor choices can affect many lives, reminding them that any failure to follow probation terms would result in imprisonment. While noting that the young men showed some understanding and growth, she made clear that accountability and respect must guide their futures. On June 6, 2018, the case came to a close in Ingham County Circuit Court, where Judge Rosemary Aquilina sentenced all three to 36 months of probation. The court also ordered them to complete sex offender treatment, group and individual therapy, cognitive behavior therapy, 100 hours of community service, and pay $1,300 in fines. Under Michigan's Homes Youthful Trainee Act, HYTA, they were granted a special status that would allow their records to remain sealed if they successfully completed probation. It began on a weekend evening at the Banks Entertainment District in Cincinnati. As a couple, Colleen and her husband David, were walking to their Uber after a night out, they were suddenly attacked. According to police and multiple witness reports, a group of men began physically assaulting David, while 18-year-old Faith Parker approached Colleen, who was sitting on the ground, and allegedly struck her. Witnesses claimed Parker returned a second time to continue the assault, even after the initial scuffle had broken up. Officers responded to the scene quickly, and Parker, who remained nearby, was taken into custody. She was charged with misdemeanor assault and disorderly conduct and held at the Hamilton County Justice Center on a $20,000 bond. Investigators reviewed body cam footage and gathered statements from 4 independent witnesses, all pointing to Parker's direct involvement. Additionally, the male victim reported that his phone, his wife's phone, and his wallet were missing after the assault. At the bond hearing, Parker's defense argued for a reduction, highlighting her lack of an adult criminal record. Her lawyer explained that she had only a few juvenile offenses and that her mother was willing to ensure her appearance in court.
Just go ahead.
Good morning.
Good morning, Judge.
I think this is set for a pretrial and a motion to reduce the bond.
That is correct, Judge.
I've read your motion to reduce the bond. Is there anything you want to say in support of it?
Yes, Your Honor, if I just may add, and just in regarding, including Criminal Rule 46 in the first district case, DeVos v. McGuffey, when considering financial conditions for the bond, the only things that can be considered are the risk of non-appearance, seriousness of the offense, and previous criminal record. Just to go into a few of those on how they relate to Ms. Parker, Your Honor, she lived in Cincinnati her whole life. She's never failed to appear in court. Her mother, Regina, is actually here in the gallery with us, and she assures that her daughter will be at every court appearance. Even if the court were to require her to come to every pre-trial conference, she will be there. Regarding the seriousness of the offense, Your Honor, this is a first-degree misdemeanor. I would just add that in DeVos v. McGuffey, that case was dealing with felonies, while we are dealing with misdemeanors. Not to belittle the charge, but I mean we are still dealing with misdemeanors, Your Honor. And as far as previous criminal record, she has no adult criminal record. Your Honor, she does have a juvenile record, and in looking at that, I see she has 1 assault and 5 nonviolent misdemeanors. Again, that is not an extensive criminal record to give her a $20,000 bond, which she currently has in the assault. Ms. Parker, she's 18 years old in an adult jail for the first time. She works at McDonald's, so if the judge were to do like a cash bond, the most she could do is $3,000 at 10%. We believe she believes that is enough, I guess, enough skin in the game to assure her appearance in the court. And if the court requires, she will come on pre-trials. But as you said, I've spoken with her mother, and her mother will assure her appearance in court, Your Honor. So we would be asking to reduce the bond to something more reasonable as $3,000 at 10% or no more bond.
The bond is currently $20,000 at 10% plus EMD, correct?
Yes, Judge.
Your Honor, if I could respond just on the factors that Mr. Behet said. The mom asserting that the defendant will come back to court. I've heard from jail phone calls that the defendant will not be living with mom. She'll be living in her own apartment, and mom does not want defendant on EMD to her home. Second, the seriousness of the offense. I watched the body cam footage. 4 independent witnesses have asserted that the male victim in this case was walking the female victim, Colleen, to an Uber, and a male assaulted David, male victim. Other males jumped in and began beating David, and Miss Parker came over to Colleen, who was seated on the ground watching her husband get beaten. Came over to Colleen and attacked her. Multiple witnesses jumped in to break it up. After the fight dispersed, Ms. Parker came back over to the female victim, Colleen, and again was trying to assault her. The police apprehended Ms. Parker because she stuck around. She was with these men that jumped David. If I could go into her criminal history a little bit, she does have a juvenile record, including assault. Mr. Behet said that the most she can afford is $300. I heard on the jail phone call the mom is prepared to pay the bond today at $2,000. So we are asking for the bond to be higher based on the seriousness of the offense.
The defense proposed a reduced bond of $3,000 or release on recognizance. However, the prosecution pushed back firmly. They emphasized the seriousness of the attack, noting that it wasn't a simple altercation, but a coordinated group assault. They also revealed that Parker would not be living with her mother, and phone calls from jail suggested her mother was unwilling to have her on electronic monitoring at home. Most powerfully, the female victim, Colleen, gave a tearful statement in court.
The victim, Colleen Herman, would like to speak to the court today.
Hi, Your Honor. I am asking that the bond not be lowered and that she remain in jail. This has been extremely traumatic for my family. I'm a stay-at-home mother of 2 babies. I've never had a fight in my life. My children have been staying with my parents because I'm too afraid to have them at my home. I haven't seen my babies in a week because I'm too afraid for them to see my face. I can't sleep at night because I keep dreaming of being punched over and over again. I can't drive without worrying. I can't go to the store without, truly, I tried to go to the store yesterday and I started crying, having a breakdown. I'm gonna have to go to therapy. I don't feel safe. And if she is out, I don't feel safe, and the people that she was with are not caught. I have no idea where they are. I am constantly in fear that they're going to attack us. So I ask that please keep my family safe and keep her in jail where hopefully, and I do pray that she has a change of heart.
She described the emotional toll the attack had taken. She hadn't seen her family in days out of fear, was unable to sleep due to nightmares, and struggled with simple daily tasks like shopping or driving. Taking all the details into account, including the video evidence, witness statements, and the victim's plea, the judge ruled that the allegations were too serious to justify any bond reduction.
That's it, Your Honor.
Was there anything to this assault? Do the parties know each other?
No, the parties do not know each other. It seems like this group of males and Miss Parker on them walking to their Uber and attacked them. There was, I would like to mention something new that came up since arraignment, and that is that the male victim had 2 phones on his person, one being his wife's and his wallet, and those were taken after the assault was concluded.
All right. Well, this does not appear to be an ordinary assault case. The allegations here are serious. I think the bond is reasonable. And so the motion to reduce the bond is overruled.
Thank you.
How do you want to proceed from here?
Your Honor, we would ask to set this for a jury trial.
Okay. Send to the assignment commissioner for a jury trial.
Thank you, Judge.
Thank you.
Parker remained in jail on the original $20,000 bond. Later, as the case progressed, Parker accepted a plea deal. One assault charge was dismissed, and she was sentenced to 3 months in jail, followed by probation. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.